We are now on the record in docket number contested case or CC-2022-OGR-01-002. It's now 9:02 a.m., Thursday, October 13th, 2022. We're at the Fruitland City Hall in Fruitland, Idaho. This is the time set to determine the factors I will consider when determining whether the terms and conditions of an integration order are just and reasonable, as provided in Idaho Code 47-320 sub 1 for the spacing unit consisting of section 30, Township 8 North, Range 4 West, Boise Meridian, Payette County, Idaho. My name is Mick Thomas. I am the Division Administrator for Minerals, Navigable Waterways, and Oil and Gas within the Idaho Department of Lands, presiding over and conducting this hearing today pursuant to Idaho Code 47-328. Before I continue, I want to let everyone know that I have reviewed all of the briefs and the comments. I will give equal weight to written and oral comments and arguments. Some housekeeping. This hearing is in person with a virtual component via Zoom. The hearing is being recorded in Zoom as required by IDAPA 0411011651. We also have a backup recording device recording the hearing. For those on Zoom, please mute your microphones until you are called on. Please speak loudly and clearly when it is your turn. If there is a disturbance, you will be reminded to mute your microphone. If the disturbance continues, you may be muted and/or disconnected. For those appearing in person, it is important that you identify yourselves by stating your name before you speak. I have a podium right up here that's in close proximity to my laptop and the recording device. I would ask, if possible, that you come up and provide comment at the podium. If you're unable to, just let me know and we'll move the stuff over to you, okay? Documents in this record, docket number CC-2022-OGR-01-002, are on the Commission website, the OGCC website at ogcc.idaho.gov/administrative-hearings. As my September 7th, 2022 notice indicates, this hearing is addressing the scope of factors used to determine just and reasonable. I am not addressing today what terms are in fact just and reasonable. That is a question for a future evidentiary hearing held at a later date. I have allowed briefing and submittal of affidavits on this issue of the scope of factors used to determine just and reasonable, and I plan to take only arguments at this hearing. I want to again clarify that the deadline for upcoming uncommitted owners to respond to the application has not passed, and they can still participate in the future evidentiary hearing on this integration application. Witnesses and evidence may be submitted at that evidentiary hearing as well. We'll proceed with the hearing as follows. I will first hear arguments from the applicant, Snake River Oil and Gas. This will be followed by arguments from uncommitted owners within the proposed unit. Afterward, I will accept arguments from the Idaho Department of Lands. Then Snake River Oil and Gas will have an opportunity for rebuttal. After argument is complete, I will accept public comment. I will limit these comments to 5 minutes. I'll first take public comments from those appearing in person, and then public comments from anyone who participates via Zoom. Again, I would like for anyone who speaks to state your name for the record. If you are here as a representative, please indicate your own name as well as those who you are representing. I may ask clarifying questions while you're speaking. Taking appearances in the order as I've described. Mr. Christian, you please identify yourself and who you represent for the record.
Thank you, Administrator. Michael Christian. I represent the applicant, Snake River Oil and Gas.
Thank you. Mr. Piotrowski, can you please unmute and identify yourself and who you represent?
James Piotrowski, Piotrowski Durand, PLLC, here representing Stephen and Robin Bishop, Amy and Jason Echevarria, Rex Wilson, and Patricia and Greg Fleshman, as well as Citizen Allied for Integrity and Accountability.
Thank you, Mr. Piotrowski. Ms. Kaufman, can you please identify yourself and who you represent?
Sure. My name is Angela Kaufman. I'm a Deputy Attorney General, and I'm here today for the Idaho Department of Lands.
Thank you. Are there other uncommitted mineral interest owners in the proposed unit that plan to participate today, either in the room or via Zoom? Okay, thank you. For the record, no one came forward there. Let's begin with the arguments. I first invite Snake River Oil and Gas to provide argument. Go forward, Mr. Christian.
Thank you, Administrator. Again, Michael Christian. I represent the applicant, Snake River Oil and Gas. I will start with the general observation that the Commission and the Department have the authority and the obligation to encourage the development of hydrocarbon resources under the Act while protecting correlative rights and preventing waste. And as you're aware, under the Act, the Act dictates that in the event of a conflict, the prevention of waste is paramount. Snake River concurs with the Department regarding the factors that should be considered in reaching an integration order. The factors that have been proposed by Snake River and the Department appear to be identical. The same factors have been used in previous integration proceedings in the aftermath of the judgment in Kaya versus Schultz, and the applicant is unaware of any site-specific conditions here that compel any additional or different factors. The uncommitted mineral interest owners in the briefing that they have submitted appear to confuse the purposes and function of integration proceedings with those related to well permit applications, which already cover many of the subjects raised by the uncommitted owners. They also ignore that several subjects they raise are already covered in the Act section on integration, section 47-320. Section 320 sub 1 actually provides for the issuance of an integration order for the drilling of a well or wells in a unit. It does not limit the operator to a single well in the unit. That issue has also already been decided by the Commission in a previous proceeding. Section 320 does not require the designation of a specific well or well location in the integration order. The details of any proposed well and its drilling and operation are addressed at length in the oil and gas rules, specifically at rules 200 and 310 through 420. Likewise, permission for and the details of well treatments are already covered in the rules, specifically at rules 210 and 211. The remainder of the issues raised by the uncommitted owners are already covered either by the factors that have been proposed by the Department of Snake River. The process arguments they make are either contrary to the clear terms of the Act or already covered by the factors proposed by the Department and the applicant. Most, if not all, of the interests alleged in their brief are either outside the scope of integration under the statute or already covered by other areas of the Act and rules, as I've just discussed. Nothing in the judgment in Kaya versus Schultz requires a granular examination of every facet of the oil and gas business, including post-production, transportation, processing, and marketing, before mineral interests may be integrated. I don't believe that the uncommitted owners have submitted any authority regarding the consideration of the various non-economic factors unrelated to the purposes of the Act and describing just and reasonable terms of an integration order. Similar terms do not appear to be included in or discussed in other states' integration orders and cases. To the contrary, other states' integration or pooling orders are often standardized and incorporate the terms related to preventing waste in the development of the resource and protecting correlative rights. For example, often using a joint operating agreement based on AAPL Form 610, and so long as the operators complied with the statutory prerequisites and scope, similar to the application for integration here. Likewise, evaluation of non-mineral property values is not an appropriate consideration in determining just and reasonable terms of integration. It is unrealistic for operators to have to prove future financial values of every property in a unit when seeking integration, effectively having to prove a negative in the future. Again, the Act does not appear to provide the Commission with authority to police private non-mineral property interests. I will note surface owner protections are contained within the Act at section 47-334. They include specific procedures and requirements, but do not provide authority for the Commission to vary from them. With respect to the mineral owners' due process arguments, appropriate parties to this matter are currently being afforded due process, not only by the procedures set forth in the Act and the rules, but also by adjustments made to the proceedings on this application specifically. For every integration application submitted, public comments can be submitted to the Department of Lands to review prior to permit approval or denial. And while they can't participate in a proceeding as a party, public witnesses can submit written or oral statements or exhibits at a hearing under the AG's rules. For this matter, the preliminary hearing on factors to be considered to reach just and reasonable terms and conditions has been moved, obviously, here to Fruitland. There's an expanded briefing schedule provided for by the administrator, which has allowed interested parties an even greater opportunity to be heard. Ultimately, to the extent an interested party wants to be heard, an opportunity is available to do so. The Commission is bound by its duty to regulate the exploration for and production of oil and gas to prevent the waste of oil and gas and to protect correlative rights, which mirrors the stated purpose of the Act itself. And I would direct you to section 315(1) of the Act. Again, the responsibility of the Department and the Commission to prevent waste is paramount. Due process in this context does not equate to essentially a free-for-all to theorize about the supposed effects of oil and gas development in general. More appropriate venues exist for policy questions, specifically the legislature. Rather, the focus under the Act remains on issuing an integration order that promotes economic development, prevents waste, and protects correlative rights. Mineral interest owners are free to present evidence regarding site-specific impacts to them from the proposed integration and to propose terms and conditions related to that evidence to the extent consistent with the Act and the Commission's jurisdiction under it. The factors, I would submit the factors proposed by the Department and the applicant are sufficient for that purpose. Thank you.
Thank you, Mr. Christian. I have a few questions for you. I think you covered a few of these in your opening just now, but I want to ask them specifically. Could you share what industry standards are when setting just and reasonable terms?
Broadly speaking, industry standards would be whether, in the context of integration, would be, for example, whether a form of joint operating agreement that's proposed is in wide use in the industry. In this case, I think it's generally understood, for example, that the APL Form 610 is very widely used in the industry and relied upon by other states, commissions, and regulators as a form they use in pooling or integration proceedings. Likewise, whether a form of lease that's proposed is of a form that is common in the industry would be another question to ask. And the broad term that's used as a producer's 88, there's a lot of different versions of that, but the applicant has in the past and should in the future put on evidence that a form of lease is both widely used in the area in the industry already on voluntary terms, and perhaps widely used by it elsewhere and by other operators. Does that answer your question?
Thank you, Mr. Christian. An additional question. Should there be a specific factor used to determine just and reasonable terms that considers how many wells are proposed and the appropriateness of terms for that number of wells? Why not?
Well, first of all, I think the Act as it exists already allows within, for example, a default spacing unit for multiple wells, as long as a well is being drilled to and completed in a separate source of supply. So to the extent you want to impose a factor, I suppose that would be it, is does the applicant propose or intend to drill wells to, if they intend to drill more than one well, do they intend to drill wells to separate sources of supply? Which I think would be generally something for them to answer in the context of integration, although I think the question of the technical details of that would be more appropriately answerable in the well permit application process.
Thank you, Mr. Christian. One more question.
Yes, sir.
Should factors used to determine just and reasonable terms consider the use of an uncommitted owner's lands, including whether a wellbore or pipeline may physically cross that land of an uncommitted mineral interest owner?
I think it's appropriate to, that's a factor that could be considered, I think for surface uses, for either pipeline or wellbore. I mean, I think it's, that falls under the rubric of encouragement of development and prevention of waste and protection of correlative resources. If hydrocarbons would be wasted, absent the ability for a wellbore to cross under an integrated party's land, then the prevention of waste would be paramount, and that traverse should be allowed. So I don't think it's an unreasonable factor to consider, but I think it has to be viewed in the context of the purposes of the Act.
Thank you, Mr. Christian. Those are all the questions I have.
Thank you.
Good morning, Mr. Piotrowski. I'd ask for you to unmute, please, and invite you to provide argument at this time.
Thank you, Mr. Thomas. We've submitted a brief in this matter. I don't want to repeat any of the arguments set out therein. You've assured us that both written and oral arguments or statements of position will be equally considered. So please consider the brief submitted, and let me raise some slightly different points here this morning. It is impossible for you to determine whether the terms of integration will be just and reasonable, particularly if you adopt the position set forth by Snake River Oil and Gas. Please allow me to explain. What you are not allowed to address, Mr. Thomas, by the statute is the amount of the royalty payment, nor the amount of the bonus payment. This is an economic transaction. My client owned oil and gas. Well, presumably. Certainly Snake River believed that my clients own oil and gas. Snake River wants to buy it, and my client don't want to sell it at the price that they've been offered. This is a financial transaction. You are to force that transaction to happen, and yet you can't modify the price in any way whatsoever. It is impossible to ensure that a transaction of an economic nature is just and reasonable if you can't control anything about the price. I want your Lexus, I'm willing to pay $1 for it, and if the statute says you must give it to me for $1, then that is statutorily required. It is not just nor reasonable. That is precisely the position my clients find themselves in. You're telling us that you, on behalf of the commission, are going to set just and reasonable terms when you don't have the power. You haven't been given the power to affect economic terms. You have also now been told, and the position that Snake River takes, and the position that the commission seems to take, is that you may not address surface trespass, that that's not something that is allowed to be considered in just and reasonable terms. You are being told that the number of wells that will be drilled, in other words, the number of times that my clients will suffer a trespass, you cannot address that as part of just and reasonable terms, the Snake River tells you. They tell you that well treatment systems, you can't address those, that is to be addressed in some other procedure. They will tell you that the appropriate bonding level for this project is not something that you can address in setting just and reasonable terms. Instead, Snake River tells you, all of those items are either entirely established as a matter of statute or should be addressed only in the well drilling permit process? Well, the well drilling permit process does not require just and reasonable terms. It does not require fairness to the mineral owners. And so that's not an answer. It doesn't address the real issue here. The real issues here are, what is the gas worth? How much should the owner of that gas get versus the out-of-state corporation that wants to come in and extract it from under our property? What surface protections will there be against trespass? What subsurface protections will there be against trespass? What protections will be provided in the event of an accident in the drilling or extraction process? All of these things are necessary to deciding whether integration is just and reasonable. And yet, you've been denied the power to determine any of those things. It's not your fault, Mr. Thomas. It's the legislative fault, as Mr. Christian properly pointed out. They have set up a statutory system that doesn't give you the power to determine whether the terms are just and reasonable. So let me address what would be necessary at a bare minimum to set just and reasonable terms in the compelled, forced economic transaction. First of all, you'd have to address the royalty amount, but you're not allowed to. Why 12.5%? Why not 15%? Why not 25%? Those are reasonable questions, and if you were deciding what is a just price for my client's mineral interest, you'd ask those questions. You'd develop answers to those questions, yet you are not allowed to do so. You would address the bonus payment, because this is an economic transaction. This is a sale, and it is not a sale between two willing arm's length transaction participants. And so, in the absence of an arm's length transaction, you have to decide what is just. Well, what was just to one property owner is not necessarily just to another. And yet, you are not allowed to determine a just or reasonable bonus payment. You would address the number of wells. The terms of a deal that call for a single trespass across somebody's property are quite different from the terms of a deal that would allow continuous or multiple trespass across a person's property. If I sell an easement for a single use, if I tell, for instance, a utility company, yes, you may cross my land one time to access other property to do something you need to do, and you pay me $10 for that one-time access, it is not then reasonable to say, well, that $10 is also all that you get for permanent and continuous access for the next 30 years. That's just neither just nor reasonable. Likewise, the number of wells is relevant. If you tell me I want to trespass upon your property and take your minerals via a well, that's one thing. If you tell me you want to drill 10 wells around my house, that's entirely a different thing. And that would require different just and reasonable terms. And yet, Mr. Christian would have you believe you have no power to address that. And he may be right. The commission believes you have no power to address that. The process here is intended not to elevate correlative rights over property rights. It is not to elevate development over all other interests. The purpose of the statute is to establish that, to encourage development, but to encourage development of our hydrocarbon resources at economically reasonable basis. If the cost of extracting the minerals exceeds the value of the minerals, Snake River Oil and Gas has the option to say, oh, no, we're not going to do that. We're not going to drill that well because it is not economically, well, it's not profitable. My clients don't have that right. They had that right until Snake River filed this application. They had the right to say, no, and that's not economically profitable. My 1/8 royalty and $100 bonus payment isn't going to make up for the losses that it suffered. But you, Mr. Thomas, are being asked to decide under what terms will one party to this transaction be denied the right to say, that's not profitable. And yet you haven't been given the tools to do so. So in addition to the arguments we raised in our brief, I would simply point out that if the determination of you as the hearing officer and ultimately the commission, because it is the commission's decision, not yours, If that decision is that a 1/8 royalty is all we get, a $100 bonus payment is all we get, we don't get any limits on the number of wells, we don't get service protection, we don't get subsurface protection, we don't get paid for trespass on our property. If that's the decision to be made, is that none of those things will be addressed in any proceeding, then you're implementing an unconstitutional statute. The fact is that unless the commission has the power to address each and every one of these matters, it is not engaged in due process of law. It is instead engaged in the application and enforcement of a statute that strips people of property rights without due process of law. Thank you very much.
Thank you, Mr. Christian. I'm taking a few notes and then I have a few questions for you. Would you mind waiting a moment?
Sure.
Thank you. I'm sorry, I think I called you Mr. Christian accidentally. That may have been egregious. I apologize for that. And just while we're on the topic of humor, I drive a Toyota truck, not a Lexus. That would be great to have, by the way, but my truck is quite reliable. Back on focus here. Mr. Piotrowski, I have one question that first question that you kind of alluded to in your statement just now and in your brief, but I want to clarify. Snake River Oil and Gas and the department have proposed using the same factors used in prior integrations, specifically docket number CC-2022-OGR-01-001 and docket number CC-2021-OGR-01-002. Do you agree with these factors? And if not, what is your alternative proposal?
No, we don't agree that those factors are sufficient or adequate. Our alternative proposal is that it's set out in our brief, and it is that the commission consider all economic and non-economic factors that reflect upon the justness and the reasonableness of forcing someone to sell part of their home against their will. Let's be very clear that that's what the statute does. And to that extent, every factor that will relate to that forced sale, that compelled participation in a process which some property owners find objectionable, need to be considered. And so if you're not going to consider the economic effect of the oil extraction, if you're not going to consider appropriate bonding and insurance levels, and if you're not going to consider the value of the royalty and the bonus payment, I don't believe you can determine just and reasonable factors.
Thank you, Mr. Piotrowski. Additional question. In your opening brief, I think it was page 8, heading B, topic B, just a reasonable term should also, you titled it, just a reasonable term should also ensure the property owner's reasonable expectations, current property use, etc. Would you mind clarifying a little bit what you mean by reasonable expectations?
Certainly. My clients, at various different times for each of them, made a decision on how to invest their money. Buying a home is not merely about finding a residence. Buying a home is the single most important economic activity that most American families will ever engage in. I have never, I'm a reasonably successful person by economic standards. I have never purchased anything more expensive than the home I live in. And that has been true in every home I lived in, when I lived in cheap homes and when I lived in more expensive ones. It is always the biggest single investment that a typical American family makes. The value of that home is not just in providing a place to lay one's head. Not only is a home a person's castle, to use the old saying, but it reflects the assumption that if smart decisions are made, if you buy a good home in a reasonable location and you take reasonably good care of it, that you will get to enjoy the market for real estate, which at the moment in Idaho is over the last 5 years now, it's been quite, I'm not even sure what word to use, Let's just say that people have seen massive gains in the value of their homes. Those are retirement funds. In addition to being a place to lay one's head, it is an investment in one's own future. And so the reasonable expectation of a person buying a home in rural Fruitland is that they will get to enjoy peace and quiet, clean air, clean water, and own an asset that will, in all probability, continue to appreciate over the course of the ownership, such that that home can then be used at some future point to allow one to retire, to pay for long-term care services is a very frequent use of one's home. And yet, these expectations, these reasonable expectations of both owning a home and owning a major investment can be dashed by an outsider forcing my clients to sell a portion of their home. Now, that portion may be underground. It is still a portion of their home. And in fact, it's not always underground. Bank River will ask you to approve surface trespass as well as subsurface trespass. And so the reasonable expectations of a homeowner in Idaho are that you can put up a fence and keep people off your property, including Snake River oil and gas. All of these things are the reasonable expectations of property owners in Idaho, and they should all be addressed if we're to determine whether certain terms are just and reasonable.
Thank you, Mr. Piotrowski. I have one more question for you. Are the four property owners mentioned in your brief and at the opening of your statement today, are those four property owners KIA members?
I'm not sure of their current membership status, but I would assume so. They have asked me to represent them, and I did not ask that question as part of whether I would represent them.
Thank you. And do you have any, I think I know the answer to this, but just for clarity, do you have any additional clients in this unit that are KIA members?
I don't know the answer to that.
All right. Mr. Piotrowski, thank you very much. That will be all. And I'll ask again while I did this in the intro, are there any uncommitted mineral interest owners in the spacing unit in the room or on Zoom who would like to speak at this time? All right, there are none. At this time, I would invite the department to provide argument. Ms. Kaufman, you can unmute.
Thank you, Mr. Thomas, and good morning. As you know, I think the Department of Lands provided an opening brief and remarks, and at this time we're just going to stand on those remarks, and we don't have anything in addition to add.
Thank you, Ms. Kaufman. I, in turn, have no additional questions for the department at this time.
Thank you.
At this point, I would allow Snake River to step forward, Mr. Christian, and offer rebuttal.
Thank you, Administrator. Briefly, Mr. Piotrowski's remarks and his view of the just and reasonable scheme on behalf of his clients it really ignores the roughly 90% of the owners in the unit who have voluntarily leased and wish to develop, and the impact on their interests. And it is not true that some of the interests that he's described of uncommitted interest owners or any property owner are not considered. You know, as I've described already, the adequacy and safety of well drilling and operation and well treatments are addressed in the rules, and there are opportunities for parties who think their interests are being affected to request notice and a hearing on a subject, or they're required, frankly. So there are already opportunities in other areas for owners to participate, have a reasonable opportunity to be heard on a subject, and ensure that their interests are protected in a number of ways that just aren't part of the integration process. I would also note that his continued description of the bonus and royalty as only, I think his suggestion is that the bonus and the royalty only buy the oil and gas, and that there are these other things that he calls trespasses which are uncompensated, and that's just not true. Certainly in the voluntary leasing context, which is the analog, your bonus and your royalty buy a lease. They don't just buy the oil and gas. And the bundle of rights that's purchased in the lease includes subsurface access for the purpose of development, and depending on the terms of the lease, surface access for the purpose of development. It is not true that those things are not compensated. And certainly in the past, the applicant has put on evidence that the bonus being paid to owners to be integrated per the statute, it is the equal to the highest bonus paid to any voluntary lessor in the unit prior to application, which goes to the subject of just compensation. The applicant has also put on evidence that the royalty being paid to all or virtually all of the owners in the unit is equal to the bonus that's being proposed in the form of lease submitted with the integration application. So it isn't true that there is no consideration of uncommitted owners' economic and other interests. But I submit to you at the end of the day that the uncommitted owners are, they ignore that the just and reasonable process is interested in the rights of all parties involved, not just the uncommitted mineral interest owners. Thank you.
Thank you, Mr. Christian. At this point, arguments are complete. I would invite those first in person who wish to make public comment to step forward and do so. Specifically, Ms. Higbee, if you'd like me to bring the laptop back to you, you could provide. I'll do that for you.
No, thank you.
Okay. So is there anyone in the room who would like to provide public comment? All right, thank you. I don't believe we have anyone else on Zoom from the public. I'll check again. All we have is Mr. Piotrowski and Ms. Kaufman. So there's no public comment offered at this just and reasonable hearing. Okay. If anybody else has anything to say, but I think I've pretty much flushed that out among the group. So with that, it is currently 9:40 a.m. This hearing is concluded. I'll take the